would have noted that on the 26th of January 2024, my erstwhile colleague, Mr. Mongeri, had filed an application dated the 24th of January 2024 an application of contempt in nature and pursuant dated the 24th of January 2024. My erstwhile colleague, Mr. Mongeri, filed an application of the nature of contempt, and this court, upon hearing that application and duly satisfying itself that the same had been served upon the predecessor counsel, Mr. Mutai, Moi and company advocates, issued warrants of arrest against the defendant herein. The record will bear as witness that there is an affidavit of service confirming service upon the same advocates, and as such, there was no legal obligation upon the plaintiff to serve the defendant in person. Regardless, upon issuance of the warrants of arrest, the defendant was notified, and again the court record will bear as witness that we have mentioned this matter countless number of times and successfully, owing to the cat and mouse games that were played by the defendant. In fact, Your Honor, there is a report that we filed in court in our last court attendance confirming private investigations that had been done and successfully upon the defendant, and requested the court to grant us an extension of time to liaise with the office of the OCS Nakuru for enforcement of the decree and orders of the courts. It is pursuant to those warrants, Your Honor, that the defendant is present in court. Now, my colleague has presented a sorry state of affairs as far as the defendant is concerned and his financial capability. However, Your Honor, I submit that there is nothing new that has been presented before these honorable courts. That information is contained in a replying affidavit that was filed before these honorable courts, sworn by the defendant on the 7th of September 2021, sworn, Your Honor, on the 7th of September 2021 in opposition to an application, a notice of motion application interim for provision of maintenance. Further, Your Honor, the proceedings of these honorable courts will bear as witness that the defendant was heard on merit. Again, he rehashed what he has mentioned to court this morning. And the predecessor courts, upon hearing the defendant and the plaintiff, arrived at a judgment that was delivered on the 2nd of June 2022. On the 2nd of June 2022. It is therefore, Your Honor, reasonably expected that upon delivery of that judgment, the defendant would have appraised the courts as to what he has done in compliance with the said judgment of the courts. Your Honor, from the submission of counsel, other than submitting on evasive grounds, there is nothing tangible that has been placed before this honorable court and or even orally submitted as to what the defendant has done in compliance with the judgment of the courts. For records purposes, the defendant was supposed to provide for education and all educational related expenses of the minors. He was to provide a medical cover for the children and was equally to share in the cost of the entertainment together with the plaintiff. Regrettably, Your Honor, there is no material that has been placed before this honorable court to show an iota of compliance. Sadly and regrettably, while he takes his responsibility casually, the minors are the ones that are getting affected. Your Honor, the firstborn child is now in Form 1 or Grade 8 at Mustard Seed School. That child, the firstborn, is year 8 at Mustard Seed International School, having completed his KCPE last year, was unable to join high school on account of lack of fees. My client reached out to the defendant to ensure placement of this child in a high school. The defendant made a promise that he would ensure the children, or rather the firstborn, was enrolled at Kabarak High School. Regrettably, that was not to be. And that minor stayed at home for 2 terms. It is only this 3rd term that my client was able to raise some funds in the best interest of this child and enroll the child in that school. Your Honor, I submit there is willful and deliberate disobedience of these court orders that were issued by this honorable court by the defendant. I have availed the current payment receipt from Mustard Seed confirming the minor's enrollment this year and of this term. And thus, Your Honor, I pray, seeing that there is no proposal whatsoever that has come from the defendant, that he be committed to civil jail, actually to jail, until such a time when he will be ready to purge the contents of these honorable courts. That's all, Your Honor.